Right. Go.
Okay.
Thank you. Good evening, everyone, and thank you very much to my warm-up artists, Ben and Thomas, for their inputs this evening, and also to Aberdeen Climate Action for having me here for my first Climate Cafe. I'm going to speak to you tonight. Obviously, I've got around about 20 minutes to speak to you this evening about people, power and planning. So I'm a practicing solicitor. I am also the law clinic manager at Robert Gordon University. I've worked in planning law, and but my background and interests very much lie in wildlife conservation, that being conservation of wildlife and their habitats. I'm the crime and advocacy advisor for Scottish Badgers, and I also sit on the Scottish Steering Group and the Wildlife Working Group for the UK Centre for Animal Law. So, like I say, I'm going to give you a high-level overview of some areas of the planning system that you might want to be mindful of based on a real-life case study. And I'm going to leave you with some non-food related takeaways that hopefully might be useful for you if you become involved in a planning matter in the future. So obviously you can see from my slides, I've used just a couple of images from local planning campaigns. We have Save St Fittick's Park, Save Canal Park, Save Sloughy Woodlands, just to name but a few of the campaigns that we have ongoing in the northeast of Scotland. I think it's all too common a story, isn't it? You know, communities forced to try and come together to battle, often at extensive personal cost, to try and save vital green spaces in the midst of a climate and biodiversity crisis. It's quite the oxymoron. My opinion, based on my experience in the planning sector, is that there's a distinct imbalance of power in the planning system, which is strongly weighted in favour of those seeking to develop as opposed to those who are directly affected by the developments. Right, so a little bit of background. Like I say, I'm going to leave you with a sort of real life case study. There's also another sort of background case study that I will talk about on the periphery, which is one that I'm directly involved in and can't give you too much info about. So, like I say, when I was working in planning, I was largely acting on behalf of developers. Many of those clients saw it as a great challenge and a thrill to kind of overcome and defeat the voices of the community who put up any resistance to their plans. That didn't sit well with my ethical position. When I left planning, I kind of inadvertently became aware of a community campaign through Facebook, and the group were objecting to the destruction of a local woodlands to make way for luxury homes. I took great pity on the group, to be honest, because although they were very active with petitions and demonstrations near the site to try and raise awareness, actually what they were doing was falling on deaf ears in terms of getting the message to the planning authority. And I contacted the group directly and asked, you know, this is great that you're raising this awareness, but what are you doing from a legal perspective? And actually, it took some weeks to get a reply. And then when I did, they didn't know what I was talking about. So I found it quite disheartening and a little worrying for them and also for the community, how little knowledge that they had of the planning system and the associated legalities that stood alongside that. So I felt that I had to get involved to try and give them a pointer in the right direction. And like I say, originally I was just kind of on the periphery of it, trying not to get too sucked into it. And the first thing that I did was try to formalise the group structure. So they'd come together, quite a few of them members of the community. So I set them up as a voluntary association with a constitution. So that's something that I would suggest, that if you are coming together as a community group, you do look at structure. And in terms of a constitution, there's some brilliant templates online, which can easily be sort of filled in just with your details are already mostly prepared on your behalf. So the reason I did that was ideally looking at the longer term impact and to try and assist them with any later legal proceedings. but I guess also to try and add some formality to what they were trying to do and who was going to do what. After I'd done that, I thoroughly sort of investigated the planning position so that I could understand what stage the planning application was at and what options were open to us to take it forward. So the application was for a local development. Like I say, it was a small number of luxury homes, and that would ordinarily be decided by an appointed person under delegated powers. So what that means is a planning officer from the planning authority, which is the local council. But to explain this a little bit further, the planning system distinguishes between three levels of development: national, major, and local. And the routes of appeal are generally based on the level of development. So, for example, what constitutes national development is set out in wider Scottish planning policy, which is the National Planning Framework. And applications for such development will be determined in accordance with that framework by the planning committee for the local authority in question. And what is classed as major development is set out in the mouthful of Town and Country Planning Hierarchy of Development Scotland Regulations 2009. Easy one for you to remember. And planning applications for any such major developments will be determined by the planning committee for the relevant local authority. So if there is to be an appeal of a national or a major development, in most cases a reporter will be appointed from DEPA. And this is the Scottish Government's Planning and Environmental Appeals Division to determine the appeal on behalf of the Scottish ministers, and it's known as a delegated appeal. On occasions when the Scottish ministers choose to determine the appeal themselves, an appointed person, which again is likely to be a reporter who works for DEPA, reports to the Scottish ministers in order to enable them to reach decision themselves on the appeal. For local developments, so these are all developments other than national or major developments, and they will normally be considered by a planning officer, as I say, at delegated level. If, however, the planning officer refuses to grant the consent for the local development, as in the case study that I will continue with the theme of through this presentation, the applicant can require the planning authority to review their case, and such a review is undertaken by the local review body. So this is a panel of councillors within the planning authority, and there are of course arguments as to how ethical this is, but that is a discussion for another day. So taking things back to the case study and the separate campaign that I've been involved with, both applications were refused at delegated level, and thus the respective applicants appealed to the local review body. So what is a local review body? As I said, this is a panel consisting of at least 3 elected councillors. An applicant can require the planning authority to review a planning application, which was dealt with originally through delegate powers, where the application is refused if it's approved subject to conditions, which obviously they don't agree with, or it is not determined within 2 months, generally speaking. So the applicant has to give notice in writing within 3 months of the date of the decision or the failure of the planning officer to determine the application in the designated time. And this must be done using a form obtained from the planning authority, and it must contain certain information. The applicant must also document all matters which they wish to raise in the review in the form or in the application to accompany the notice of review, and together with all documents, material and evidence that they tend to rely upon. This is known as front loading, which is now commonplace across all planning appeals at all levels. So again, we've touched upon the fact that local review body consists of 3 elected councillors. It's often much more than that. So I've already touched upon the ethical argument as to whether a planning authority decision at delegated level should be then reviewed at a later point by another panel within the same organisation. I'm going to show you a video. Unfortunately, we can't get the sound to work on the video. It is captioned, so hopefully you'll be able to follow it along. Just this video is basically follows the plight of a campaign group in Carmunnock, which is near Glasgow. I'm sure Ben is maybe familiar with this one. Let's see if we can get it to play. I've chosen to show you this one because I think it's quite a powerful video. And like I say, it very closely reflects some of the campaigns that I've been involved in. and it will set the scene for what I'm going to talk to you about next. So I think we can all agree that that's quite a powerful message that campaign gets across. I'm sorry if the volume didn't come through to so you could all hear it properly. You can certainly find that video on YouTube. I think if you go to the Planning Democracy channel, Ben, would that be right? A nod for yes. Thank you. Then you might find it on there as well, or I'm happy to maybe I could pop it in the chat or something if that's useful. So obviously picking up on that video, some of the key points were that obviously, trust has been put into the local review bodies to make decisions, which, the expectation from Scottish Government guidance is that the review will be demonstrably fair and transparent. And that comes from a Planning Circular 7 from 2009. However, the reality is that, it can be very different. Members participating in review cases are expected to receive appropriate training in planning issues and in holding hearings. But often is the case that they haven't read the papers in advance, they're ill prepared for these meetings, they haven't undertaken the necessary reading or research to understand the full circumstances surrounding what they're being asked to consider. And this was particularly true with that case study, but also the campaign that I've had personal involvement in, where councillors were simply sought to grant motions for the consent to be approved with insufficient supporting evidence as to why that should be the case. So this is an area that I would suggest that you pay particular attention to, and remember that if you think that a councillor has not acted appropriately and in line with the councillor's code of conduct, then you can lodge a complaint with the Ethical Standards Commissioner. And they will obviously do an initial sift, and then it will eventually go to the Standards Commissioner if it's to be taken up. And you'll see from the slide that I've popped some links there. There's a link to the Standards Commission website. There is the Councillor's Code of Conduct, and also a link to the Ethical Standards Commissioner. And I've put on a link there as well to the Public Services Ombudsman. Now, that's basically if you think that the planning authority as a whole has perhaps not acted reasonably, then you could consider raising the matter with the Public Services Ombudsman. So what happens next? So if we look at our case studies, obviously we've gone, the planning application has been refused by a planning officer. The applicant has then appealed it to the local review body, who has decided to grant the consent, shall we say. So the next step is that it is possible for you as a third party to take a statutory review challenge to the Court of Session. But as Ben alluded to already, this has to be done within quite strict timescales, and that is within 6 weeks of the decision being made. And if you do this, the route considers the manner in which a decision was made rather than the merits of the case. So, for example, was the process to reach the decision correctly followed, as opposed to whether the particular decision was correct or not. There may also be an option to challenge the decision by means of a judicial review, known as a JR. This is a means by which the administrative decisions of public bodies, including planning authorities and Scottish ministers, can be challenged on the basis of illegality, procedural impropriety, or rationality. But this is a trickier route, as the person making the application must have standing or title to sue, as well as sufficient interest to do so, and this can significantly limit those who engage in this process. So you can see that already you're just kind of into the planning process, and there are all these different aspects you need to consider, and that's not even taking account of the funding side of things, which again, helpfully, Ben has already touched upon. Well, lawyers are expensive. We know how to charge. Litigation is expensive. So obviously you're going to have to consider, if you're going to take on a community campaign, how are you going to fund the legal fees associated with it? So legal aid could be an option if there's someone in the group who has sufficient direct interest in the matter and satisfies the income criteria for legal aid, and the application could potentially be made in their name, but it's not foolproof. The person, as Ben's already mentioned, the person applying could find themselves having to take responsibility for the payment of expenses if the application is not successful. There is potential for what's known as a protective expenses order, which could assist. This is an order which regulates the scope of a party's liability and expenses in certain types of environmental litigation. The alternative, of course, is to try and raise funds directly. Try and do this yourself. There are some good platforms for this that have been successful. Crowd Justice is one of them. It's a very popular platform where you can set out your campaign and obviously share that across social media. There was an English campaign recently called Save Swanscombe Peninsula. Don't know if I pronounced that right, which was a SSI. And they raised over £50,000 through an online crowdfunder. So it's certainly something that can be done, but obviously you would have to consider how you were going to get that out into the wider community to ensure that people were aware of it. There is also the possibility of forming a coalition with conservation charities, depending upon the scale of the development and the impact that it might have on wildlife and wildlife habitat. So it might be worth contacting some agencies such as RSPB, Butterfly Conservation, Wild Justice, Trees for Life, these kind of people, depending upon the circumstances. And if they can't help, then they may well be able to put their support behind the campaign. In some cases I've been involved in, we've had statements from Butterfly Conservation, for example, to say that they don't feel that the development should proceed. So that can be useful. Understandably, though, funding is where so many campaigns hit the rocks. And people rightly worry about the personal liability for costs that may be placed on them, or they've no idea how they're going to raise the funds. And indeed, my understanding of the campaign in the video is that it didn't progress in the end on the basis of funding largely, and they went down a different route. So perhaps a little bit rose tinted from my perspective, but my view is you don't know until you try. And I think that you have to, look at all the options and assess them, one by one to see what your options are and how best to move things forward. Don't give up too easily, I guess, would be my message from that. So non-food related takeaways. First of all, I think the key thing, so I've basically put these takeaways together based on some points that have been raised with me as a planning lawyer previously. And I think the first one is know what you're dealing with. Is it a planning application, or is it a designation in a local development plan, or is it simply a pre-application consultation? You need to know what it is you're dealing with to know how you're going to attack it, basically. And that leads me into my next point, which is you need to know what stage the process is at. Ben mentioned deadlines, very, very important. If you miss your deadline, you've missed your opportunity to get your voice across. The deadlines can be very tight. Often they can be maybe 28 days from a date of a decision. They can vary, to be honest. But what I would suggest is that if there's a deadline, get it in the diary, give yourself a few days grace so that you're aware that it's coming towards the end of that deadline, and so that you can be prepared to get everything ready to lodge. If you're objecting, this is really important, and this is a particular bugbear of mine, to be honest. Soapbox time. So your objection has to be based on planning policy, such as the local development plan. You'll find a copy of your local development plan on your local council website. And it also should be based on material considerations. Okay, so planning legislation states, little quote, in dealing with an application for planning permission, the decision maker shall have regard to the provisions of the development plan, insofar as material to the application and to any other material considerations. Okay, so as I said, if you're objecting, it must be based on planning policy and these material considerations. So I've seen objections recently where the person submitting has simply said, I don't want this development. And then they've submitted the same thing about 8 or 9 times. That will not wash. That will not have the desired effect. It needs to be quality. Quantity is good if the quality is good, but it really has to be well considered. So, material considerations. Unhelpfully, there is not a statutory definition of what a material consideration is, and its meaning has very much been developed through case law over time. There obviously isn't time this evening to go through every single point as to what might constitute a material consideration, but to give you a little insight, it could be an undesirable use, economic and social impact of the development, preservation of an existing use, sustainability and environmental control. For example, like I say, just a tiny little snippet of what could be considered. If you go onto the Planning Democracy website, then you will find there a very useful guide which tells you how to respond to a planning application. Fabulous fact sheet, well worth a look at, and it takes you through material considerations and how you might want to formulate your objection. So the next part feeds into that. If you're rallying support in the local community against this proposed development, you need to let any other potential objectors know that their objection needs to be based on planning policy and material considerations. It's not a good use of your time just to go, you'll want to object to this. You need to say, look, you want to object to this, and this is the grounds on which you should be looking at. Okay, share your knowledge with them. Share the fact sheet with them. Possibly a skeleton template as to what they could consider. I'm not suggesting you write it for them, but just look at this. This is the skeleton. that you might, want to try and follow. And lastly on this page, people power is great for raising awareness about your campaign, maybe getting the press involved, MSPs, that kind of thing. Nice little photo shots with the MSPs on site. Fantastic. But actually, what you need is you need to understand the process, and you need to know how to garner public interest to ensure that quality objections are submitted. One of the campaigns I was involved in, they collected over 6,000 signatures on a petition, 6,000 signatures from the community. They submitted it to the council, and the council went, "No, thank you very much. That changes absolutely nothing. You've just wasted your time there." So good old-fashioned people power, it has its place, but if you really want to make an impact, you need to look at how you can do that using the planning process that exists. Right, so next, know who can help you and don't be afraid to ask for help. So obviously these two kind of tie into each other. There's lots of great information and resources available online. I've listed some of the organisations who I've had a little bit involvement with. Like I say, Planning Democracy. Ben can probably speak at great length about Planning Democracy, and obviously the tie-in with the Environmental Rights Centre for Scotland. But fantastic, great resources. There's a Planning Advice Centre, sorry, Planning Advice Scotland, who I believe are a charitable organisation. I've not had so much to do with them. Obviously there are university law clinics across Scotland. Little plug for my own one here. We are soon to be launching a climate clinic, which will focus upon planning, development and environmental issues affecting members of the community on lower incomes. So that we're trying to bridge the access to justice gap in terms of these issues. And we're working with lots of different agencies on that. So if you want to keep up to date with what we're doing, we're on Facebook, we're on Twitter. We are currently going through a big rebrand, but you can find us under RGU Law Clinic for the meantime, and we will post updates on there as to what we're getting up to. As I've said, don't be afraid to ask for help. If you're stuck, find the right person to speak to and ask for help, or just ask one of these agencies and they'll point you in the direction as to who you can speak to. Be thorough. So I like this one because I'm a thorough kind of person. And, I think if you really want to achieve something, then you have to make sure that there's no stone unturned. Really look at every possible avenue of challenge throughout the process. And, as much as I hate to say it, there's more than one way to skin a cat. I'm hoping my own cats didn't hear that. But, in the campaign that I'm involved in, the councillors, or one of the campaigns I've been involved in, councillors have been reported to, ethical standards, local authorities reported to Public Services Ombudsman. Leave no stone unturned, like I say. And that sort of ties into my next point, which is don't give up. It's really easy to give up and think this is too hard, put it on the too difficult pile. And that kind of leads me into my last point, which is this little takeaway. So if not now, then when? And if not me, then who? So if you give up, nothing's ever going to change. And we need trailblazers to set precedents to pave the way for other challenges in the future. Don't rely on somebody else to be the change when you can do it yourself. It's just like I say, it's just, asking the right questions of the right people and taking things forward. It's totally in your hands to do that. And lastly, there's me. My email address is there. I can pop that in the chat. Happy to take any questions. I think we've got a little Q&A session about to come up. If you don't want to ask me your question live, then please feel free to pop me an email and I shall do my best. Not a guru on the subject. I obviously just have learned from experience. But if I don't know, I can certainly signpost you the right direction. Thank you very much.
Thank you very much, Hannah. And what a marvelous second to last slide from Malcolm X as a message to people who are interested in climate change.